This is Joe Ford with the State Bar of Wisconsin. We're here at the 2016 annual meeting and conference. I'm here with Paul Clement, who just kicked off the conference with a presentation on the Roberts Court. Paul has argued 83 cases before the U.S. Supreme Court and 6 cases just this past term. Paul, welcome.
Thanks. It's great to be here.
So, Paul, you kind of hit on 3 major topics, and I want to kind of go through those a little bit with you. The first was the impact of the late Justice Antonin Scalia. I know that you served as his law clerk starting out, and so I wondered what was his impact on the court?
You know, Justice Scalia, I think, served on the court for 30 years as an associate justice, and what I wanted to convey is just that he is just not an ordinary associate justice. I mean, his impact on a number of areas of the law has been really substantial and outsized. I think 3 in particular are on the area of statutory construction, where he really got his colleagues to focus first and foremost on the text of the statute, and not on the legislative history or the purposes behind it. I don't know that he ever got to the point of convincing all of his colleagues never to look at the legislative history, but he really did reorient the court towards the text of the statute. In a similar way, in constitutional law, he really focused the court's attention on the original public meaning of the terms in the Constitution, because he believed that's what really gave them legitimacy as the supreme law of the land, how those words were understood by the framers and by the people who ratified the Constitution or who approved the amendments to the Constitution. And then the third area, and one that obviously affected me quite a bit in my job, is at oral argument. He came to the Supreme Court from the D.C. Circuit, where he was used to being an active questioner. He started actively questioning advocates in his very first argument as a justice and never stopped. And the court really changed from a place where there might be half a dozen to a dozen questions of lawyers in the course of a whole argument to a place where you can get half a dozen questions in your first 2 minutes.
And so you mentioned how the court viewed statutory interpretation before he started. What was it like before he got there?
Before he got to the court, when the court was interpreting a statute in a case, it would, very typically, say that the text of the statute appears in the margin, by which they meant a footnote in the case, and then the text would not be mentioned again in the court's opinion, and it would really be a discussion of something about the legislative history, but mostly a policy debate about kind of what would further Congress's broad, objectives in the statute. And so I think, to go from that, where the text of the statute was relegated to a footnote, to a world where the text is, the star attraction in a statutory construction opinion, that's a pretty transformative effect.
Tell us, do you have any maybe anecdotes about your time as a law clerk for him and what he was like and how he did things? He
was a great justice to clerk for, I think, principally because you see him, if you ever seen him give a public speech or at oral argument, he's very personable, very interactive, tests advocates with hard questions. That's exactly the way he was in chambers. And compared to, I think, other clerkships that, talking to other people who clerked for different justices, almost the entire clerkship was done orally. I mean, some justices asked their law clerks to prepare really long bench memos and things like that about cases. He wanted a 1-page bench memo that just summarized the basics of the case, and then he wanted to talk about it. And it was both a lot of fun, but also a great experience for a young lawyer, because here you are talking about constitutional law with one of the justices in a way where there's a lot of back and forth and testing, and just a great experience for, I think, all of the people like me that got an opportunity to clerk for him.
And so when we talk about his impact and his legacy, and you mentioned that the court, there are some areas in which the court moving forward may change and may do things the same, or things won't change as much. What are some of those areas that you think the court will continue? What Scalia added to the court, and what may change moving forward with a new justice coming in?
Yeah, well, I think on the oral argument, whoever replaces ultimately Justice Scalia won't be, I think, as active at oral argument as Justice Scalia was. I think that change is, as permanent as things get at the Supreme Court. I mean, you take the long view, I suppose things could eventually flow back to the old days, but I kind of doubt it. I mean, every member of the court in the last 4 justices who've joined the court ask more questions than the justice they replaced. Everybody sort of now kind of accepts that the art of oral argument before the Supreme Court is the art of answering questions. And I just don't see that changing. So I think that's pretty permanent. I tend to think that his effect on statutory interpretation will have some real staying power too. I think there will be kind of some less focus on the text, some backsliding. But I've tried to, in the course of my advocacy, look for statutory constructions of opinions of every member of the current court, and I found very strong examples where they say that the analysis starts with the text of the statute, and if the text is clear, it ends there. And so, I do think that although there may be a few cases that get decided a little bit differently, because he won't be there kind of railing against the use of the legislative history or whatever it is, I think that's going to have a real consequential change for the long haul.
And you mentioned the possibility of a Merrick Garland becoming a justice, if that is possible. But you did say that there are areas in which he could possibly move the court to the right.
Yeah, I think it's obviously against the sort of dominant narrative that if Judge Garland became Justice Garland, that would have effect of moving the court to the left on a lot of issues. And I think that's true as to a lot of issues. But one set of issues where I think it would probably have the opposite effect is in the area of criminal law, and particularly scope of the Sixth Amendment, scope of the Confrontation Clause, and the reach of federal statutes. Because Judge Garland was a former federal prosecutor. I think he's rightly described as being a more moderate judge on the D.C. Circuit, but a lot of his moderation comes from siding with the government in criminal cases. And and Justice Scalia was pretty tough on the federal government in a lot of criminal cases. Not all of them. There's some issues. He wasn't a fan of the exclusionary rule. Wasn't particularly big fan of the court's Eighth Amendment jurisprudence. But in a lot of areas, he was very good vote for criminal defendants. And I think that's like a change that I think some people don't see coming, because they haven't sort of really focused on that aspect of Justice Scalia's jurisprudence, and maybe haven't focused as much on that aspect of Judge Garland's jurisprudence.
Switching gears a little bit, you talked about the Supreme Court is on the cusp of some big decisions that may come out in the next couple of weeks. And you talked a little bit about the challenges of an 8-justice court. And you mentioned sort of 3 options that they might have if cases come out that way, if they
Right.
come out with a 4. So can you talk a little bit about what those 4 options may be for them?
Sure. Well, the most obvious option for the court, if they're 8 justices and they're divided 4-4, is to simply issue like a 1-sentence per curiam opinion that has the effect of affirming the lower court decision. But that's not very satisfying, because the court took the case in order to typically resolve some issue. And so if they don't resolve it and just leave things kind of where they were when they took the case, I think that's something they've done in a couple of cases already, and they may do it in 1 or 2 more. But I think that's an option that has some downsides. Another option, which you clearly see I think they've done in a couple of cases, is to maybe decide a more narrow issue than they were originally going to decide when they took the case. So maybe they took the case to decide some broad issue on which they're divided 4-4, and they end up deciding the case on some narrower issue where they can get together a broader majority. And then the last option they have is to order re-argument. And they haven't done that on any of the cases yet. But I think we could learn at the end of the term that there's 1 or 2 cases that they hold over and then have re-argument next year.
Finally, you had a question. Someone asked a question at the end of your presentation. They asked you to compare the Roberts Court with the Rehnquist Court. What are the biggest differences that you see there?
Well, I think the biggest differences are the substance of a few areas of the law, and I think most of them really flow from the replacement of Justice O'Connor with Justice Alito. Because, you know, it's been interesting that, you know, both President Bush and President Obama have, you know, picked justices who I think so far have, you know, been the kind of justices they were looking for. I mean, they haven't, you know, sometimes a president will pick a justice and they end up, you know, deciding cases very differently from the way that most people thought they would. But with the four most recent appointments, that really hasn't happened. And then they've all replaced justices that were, you know, sort of, you know, have voted similarly to the justices they're replacing. So there hasn't been as much change as you might expect with four new justices on the court over the course of the first 10 years of the Roberts Court. But the biggest, most consequential change was Justice Alito for Justice O'Connor. I think you've seen that in certain areas of the law where, you know, Justice O'Connor, you know, I think, you know, I pointed out, you know, there's a case involving, you know, race in schools and the parents involved case. I think that might have been decided differently if Justice O'Connor were still on the court. You know, Justice O'Connor, you know, voted in the majority in the McConnell case, including part of that case that was overruled in Citizens United. So that's another pretty clear example where the law has moved because of that. So I think that's probably the single biggest difference between the kind of late Rehnquist court and the first 10 years of the Roberts Court.
Paul, I want to thank you so much for talking with us. Hope you enjoyed this. Again, thanks so much, and really appreciate you coming to the State Bar and speaking to the members at the annual meeting and conference.
My pleasure. My pleasure.